Have a quick question Friday. Today's question comes from a promoter wanting to know what are some of the deal points they need to discuss with an artist they're thinking about bringing in to a venue. I'm assuming it's a club before they have me draft the agreement. So I think there are 4 important points that you should discuss with the artist or their team ahead of time when deciding if you're going to bring them in to perform. First thing is payment, and really, when is payment due? Most agreements require that the initial deposit be made up front to secure their time, which is typically fair. The biggest one is the second deposit. When is that deposit due to the artist? Is it due immediately when they show up? Is it due after sound check? Is it due after they actually perform the services? When is that deposit due? And that's going to be important as the promoter to you, because in the event, for instance, they say, well, no, I have to get paid before I even perform, then you need to know that ahead of time, and y'all need to discuss what that looks like. Maybe you break that second payment down into 3 payments just so you know at the end of the day, they are actually going to hit the stage and provide the service. Second thing, services. How many songs are they going to perform? How long are they supposed to be in the venue if you're wanting them to do one song and then hang out for 2 hours? Let's say you may want some DJing, hosting type services. Be very specific on what your expectation of services are for that particular artist. So then, once again, when you get to the end, you're not saying, well, no, you breached the contract because you did not provide the services that we were supposed to, or that we agreed to, basically. Third thing, recording. In the world of social media and wanting to create content, you may want to record their performances if they're doing some songs or what have you. Be specific in asking that question or making sure that you are allowed to do so, getting that permission. Oftentimes, the agreements include likeness and image clauses, which allow you to promote the event, use their picture, things of that nature. But it does not relate to the recording of their performance and the use of that performance recording in the future. So you specifically want to ask to do that if you intend to use footage or do anything like that in the future on your social platforms or what have you. And then fourth is cancellation. What happens if the artist cancels on you? Of course, they're always going to protect themselves in saying that, hey, if you cancel the event, if it's on you, I still want full payment. But what if the artist is a no-show or they cancel ahead of time? What does the cancellation look like? Of course, the obvious is, well, you'll just get your feedback that you've paid them. Well, what if they cancel, let's say 2 weeks before the show? Well, of course, at this point, you spend all this money, expenses, promotion, yada, yada, yada. You may then want them to say, okay, well, I want you to then pay for some of the money we've expended, because at this point the show may, not happen or what have you. Now, I'm not going to tell you all that it is going to be an easy thing to get them to agree to, but it may be worth having the conversation ahead of time so you can avoid future litigation if they do not show up and you end up having to sue them, okay? As always, leave your quick question Friday questions in my comments or send them to me in my DMs. If you have any entertainment law matters that you like to discuss one-on-one, feel free to give me a call.